Hello and welcome to Verdictum. I'm Sheetal Joon and you're watching today's legal news where we update you with the latest legal developments across the country and world. Starting with the headlines. Domestic Violence Act applicable to every woman irrespective of religion, Supreme Court. Karnataka High Court refuses to quash proceedings in Bar Council fund misuse case. Delhi High Court asks Aviation Ministry to address AirSewa portal issues. Supreme Court upholds High Court ruling on promotion of Major General. Now the news in detail. The Supreme Court has reiterated that the Protection of Women from Domestic Violence Act 2005 is a civil law applicable to all women in India, irrespective of their religious or social background. The ruling highlights the Act's objective as it is a legislation designed to protect women from domestic abuse within a domestic relationship and safeguard their interest as enshrined in the Constitution. A division bench comprising of Justice B.V. Nagaratna and Justice N. Koteswar Singh made this observation while delivering a judgment on an appeal filed by a woman against a Karnataka High Court ruling. The case pertained to grant of maintenance and compensation under the Act. The Act is a piece of civil code which is applicable to every woman in India irrespective of her religious affiliation and or her social background for a more effective protection of her rights guaranteed under the Constitution, the bench stated. It highlighted the importance of Section 25 which permits either the aggrieved person or the respondent to seek modifications to an order if there is a significant change in the circumstances. These changes can be financial such as variation in income or relate to any other life circumstances affecting the parties involved. The court further clarified that any order for modification or revocation under Section 25(2) must be prospective, meaning it applies only from the date of the order onwards. The bench emphasized that the husband could not demand a retrospective change to reclaim maintenance already paid. The Karnataka High Court has refused to quash proceedings against the President and Vice President of the Karnataka State Bar Council in relation to the alleged misappropriation of funds or corruption in the Bar Council. The Vidhana Sauda police had registered the case for cheating, misappropriation, forgery and other offences based on the complaint filed by S. Basava Raja, a senior advocate and also member of the KSBC. The petition was filed by Vishal Raghu and Vinay Manglekar, chairman and vice chairman of the KSBC, retrospectively, and Pottu Godwa, the manager and the former member of the KSBC. The complaint pertains to the alleged misappropriation of funds in the conduct of the state-level conference of the KSBC held at Mysuru in August 2023. The complainant claimed that he filed a complaint with the chairman of the Bar Council with details of the irregularities. The chairman had constituted a committee that consisted of the petitioners as members. It is then the complainant approached that the police station and an FIR was registered. The petitioners claimed that there was no misappropriation and the money was properly spent. It was further submitted that on May 25, 2024, the KSBC had passed a resolution to close the issue to which the complainant was also a signatory. On the other hand, the complainant argued that there was no resolution to close the entire issue and said that the abundant evidence is available against the petitioners. Justice M. Nagaprasanna noted that the issue projected is misappropriation of funds and that there are certain communications made by those persons to whom expenditure is shown that they have received the amount. The Delhi High Court has instructed the Aviation Ministry to address inefficiencies in the AirSewa portal within 4 weeks. The court's directive came in response to a public interest litigation highlighting the failure of the portal to function as an effective grievance redressal platform for air travelers. AirSewa, designed to provide a streamlined process for handling complaints from air passengers, has reportedly become largely unresponsive. This has resulted in a major backlog of unresolved issues mainly affecting Indian citizens living abroad who rely on the platform to address travel-related grievances. The PIL was filed by the NGO Pravasi Legal Cell through advocate Manas P. Hamid, emphasizing the decline in the portal's functionality over the past year. A bench led by Acting Chief Justice Manmohan and Justice Tushar Rao Gadela directed the ministry to take swift action in resolving these issues. The plea stressed that the hardship faced by travelers, mainly those abroad, who must resort to Indian consumer courts for solutions, a process that is often impractical given the geographical and logistical challenges. The court's intervention came after repeated representations to the authorities failed to produce any substantial improvements in the AirSewa portal. The Supreme Court has upheld a judgment of the Delhi High Court that had directed the army to consider a Major General for elevation to the rank of the Lieutenant General after it had emerged that the officer was being denied his due promotion even though his adverse reports has been set aside. The High Court interfered with the decision of the Armed Forces Tribunal and held that it was a case of wrongful downgrading of confidential report and it was declared to be a case of injustice done to Major General ranked officer. The apex court said, dismissing an appeal filed by the Union of India against the High Court's order, a bench comprising of Justice Harishikesh Roy and Justice S.V.N. Bhatti observed in their order that the central government had granted partial redress to the officer by way of expunction of his grading on grounds of inconsistency. In July, the Delhi High Court, while questioning procedural delays in the grievance redressal system, had held the Army's refusal to reconsider the Major General for promotion even after his adverse confidential report was set aside by the central government as arbitrary and illegal. Quashing an order by the Armed Forces Tribunal that had denied him the relief, the High Court ruled that such an officer cannot be told that even though the downgrading of his CR by his superior officers was illegal and has been subsequently set aside by the central government, he would still continue to be deprived of his rightful promotion and his junior has already been promoted in the meanwhile and he will be required to wait for accrual of the next vacancy. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for the latest legal updates.